The Supreme Court handed down a decision that you probably missed, but it is already reshaping your rights during police encounters. In a unanimous 9-0 ruling, the justices fundamentally challenged the way officers can enter your home or seize your property under the guise of community caretaking. This isn't just academic legal theory. It is a shield that you need to know how to hold up if you are ever pulled over or face a police interaction. Most people think they know their Fourth Amendment rights, but the line between public safety and warrantless seizure has just been redrawn. I'm going to explain exactly what this means, why the old rules are shifting, and the critical mistakes you might make if you don't understand how this applies to your vehicle and your firearm. This could be the difference between keeping your property and facing a long, expensive legal battle. If you want to stay ahead of these quiet, high-stakes legal shifts that affect your daily life and your constitutional rights, make sure you hit that subscribe button. We break down the law so you don't have to guess when you are standing on the side of the road, and we make sure you have the context you need to navigate these interactions safely. Staying informed is the first step toward being prepared, and knowing your rights is the only way to effectively protect your family and your future. Join us as we unpack the details that the mainstream media often ignores, giving you the clear, actionable legal knowledge that every gun owner should have in their back pocket. The case we are talking about is Caniglia versus Strom, decided by the Supreme Court in 2021. It was a unanimous 9-0 vote, meaning every single justice on the court agreed on the outcome, which is a rare and powerful signal in today's legal environment. The core of this case was about the community caretaking doctrine, a legal rule that police have used for years to justify entering homes or taking property without a warrant. Officers often argue that they are not acting as investigators looking for a crime, but rather as helpful community caretakers who are simply ensuring that everything is safe. It sounds like a benign concept, but in practice, it has become a massive loophole that allows officers to bypass the Fourth Amendment, which is the part of the Constitution that protects you against unreasonable searches and seizures. In the Caniglia case, police entered a man's home to seize his firearms because they were worried about his mental health, even though he was not committing a crime and had not consented to them entering his house. The Supreme Court put a stop to this behavior, ruling that the community caretaking exception does not give police a blank check to enter your home or seize your belongings whenever they feel like it. While this case was specifically about a home, the legal reasoning behind it is creating ripples that are reaching far beyond your front door. It is now forcing courts across the country to look closer at whether the same justification is being used inappropriately during traffic stops and other public encounters. This is where it gets personal because the police do not just operate with this caretaking logic in your living room. They use it on the highway and during roadside investigations. Think about how many times you have heard an officer say they are just checking on your safety or inventorying your vehicle. When you are pulled over, if an officer decides to use the community caretaking excuse to search your car or grab your firearm without a clear, specific reason, they are leaning on the very logic that the Supreme Court just narrowed. If you don't understand how to assert your rights in that moment, you might lose your property for months or even years while you fight to get it back. I want to hear your thoughts on this, so drop a comment below and let me know if you have ever felt like an officer was using a safety excuse to dig through your things. Do you feel like the line between public service and constitutional overreach has become blurred in your area? Every story you share helps paint a clearer picture of what is happening on the ground for real people across the country. And if you find this breakdown helpful, please hit that like button to help other people find this information. Because the more we understand these rulings, the better we can navigate these high-pressure situations safely and legally. To understand why this is so risky for you, imagine you are driving home late at night and you get pulled over for a minor traffic violation, like a broken taillight or drifting slightly in your lane. You have your concealed carry firearm in the glove box or center console, properly secured, and you have your permit ready to go. The officer approaches, you inform them of your firearm, and everything seems standard until they ask you to step out of the vehicle. Then, they decide to remove the firearm from your car, claiming it is for the safety of everyone on the scene or as part of a community caretaking inventory of your vehicle. Before this ruling, many officers would do this without a second thought, and courts would often back them up because the community caretaking label was seen as a catch-all justification. Now, however, the playing field has changed, but here is the dangerous part. Police departments and local officers are often slow to catch up to Supreme Court rulings, or they simply choose to ignore them until they are forced to change. If you don't realize that the officer's caretaking claim might be a violation of your rights, you might just hand over your property, thinking you are being compliant. In reality, you might be waiving your Fourth Amendment rights and creating a permanent record that could complicate your gun ownership or your legal standing for years to come. This leads us to the hidden trap that most people fall into, which is the belief that if I have nothing to hide, I have nothing to fear. This is a dangerous mindset because legal interactions are not about whether you are a bad person or a criminal. They are about whether you have asserted your rights to protect your privacy and your property. If you voluntarily give consent to a search or allow an officer to take your firearm based on a vague justification, you are essentially erasing your own constitutional protections. You have to understand that the police are not there to explain the law to you, and they are not there to look out for your best interests. The bigger issue here is that the lower courts are still messy, and while the Supreme Court said what the rule is, how it is applied in a stressful traffic stop is still up for debate. This is where you need to be smart, calm, and firm. You need to know that just because an officer says they are securing your property for safety, it doesn't mean they actually have the legal authority to do so in every single circumstance. This is where the next fight is happening, and it is happening in police stations and courtrooms across the country right now. If you are wondering what happens next and why this story is actually much bigger than a single home entry case, make sure you are subscribed to this channel. I am going to be tracking how lower courts are twisting or applying this ruling in the coming months, and you don't want to miss the updates that could change the way you handle police encounters. We are going deep into the legal strategies that are being used to challenge these overreaches, and I want to make sure you are fully prepared to handle whatever comes your way. Staying ahead of these changes is the only way to keep your rights secure. Let's look at another scenario to make this very real for you, because these situations happen every single day. Imagine you are traveling through a jurisdiction that is not very friendly to gun owners, and you get stopped for a technicality. The officer realizes you are a concealed carrier and starts asking invasive questions about your destination, your plans, and your reason for carrying. They might even try to suggest that your vehicle is not safe or that you need to be disarmed while they process the stop, leaning on that same community caretaking logic to justify the seizure. Many people, in their attempt to be respectful and cooperative, will just say, "Sure, go ahead," or "I understand." You might think that being polite will get you back on the road faster, but that is a gamble you cannot afford to take. By consenting, you are effectively wiping away the protections that the Supreme Court just reinforced in the Caniglia case. If you do not explicitly state that you do not consent to a search or a seizure, you're making it incredibly difficult for a lawyer to help you later on if that firearm is seized or if you are arrested. A third scenario to keep in mind is the wellness check or welfare check that goes wrong. Perhaps you have a family member who is concerned about you, or a neighbor sees something they don't quite understand and they call the police. The officers show up at your door or pull you over because they claim they have a report of a person in distress. They use this wellness excuse to demand access to your home or your car, looking for anything that might be a safety concern, including your firearms. Because the Supreme Court has now explicitly limited the community caretaking doctrine, the legal ground for these types of seizures is much shakier than it used to be. However, you are still the one who has to be the gatekeeper of your own rights. You have to be able to politely, clearly, and firmly state that you are not consenting to a search or a seizure while remaining respectful so that the situation does not escalate. This is an incredibly delicate balance, and it requires you to be cool-headed and fully aware of the legal boundary that has been established by the highest court in the land. There are a lot of myths floating around social media about this, and it is important that we cut through the noise so you are not misled. One common myth is that Supreme Court rulings are like magic wands that immediately stop all police misconduct the moment they are released. That is simply not true, because police departments operate under local policies and state laws that are often far behind the curve. An officer on the street may not even know about the Caniglia ruling, or they may have been trained to use the community caretaking excuse regardless of what the Supreme Court says. Another myth is that you can just argue your case on the side of the road and win if you are right. You will never win an argument with a police officer on the side of the road, and trying to act like a lawyer during a traffic stop is a recipe for disaster. The time for the legal argument is in the courtroom, after the fact, with your attorney. On the side of the road, your goal is to be safe, to clearly state your lack of consent, and to survive the encounter without escalating the situation. A third myth is that the community caretaking doctrine is completely dead and gone. While the Supreme Court significantly weakened it, they did not destroy it entirely. It still applies in limited, legitimate situations, such as when police are dealing with an abandoned vehicle that is blocking traffic, or when there is an immediate, obvious, and undeniable emergency that requires intervention. The problem arises when police try to stretch that narrow definition to cover routine stops, or to go on fishing expeditions for evidence or firearms. The reality is that we are in a transition period where the legal rules are shifting, but the culture of policing is catching up slowly. This creates a dangerous middle ground where you might be standing on solid legal footing, but the officer in front of you might still be operating under the old incorrect assumptions. This is why your personal knowledge is so important, and why you should treat every interaction with the assumption that your rights are yours to protect, not the officer's to grant. You must take personal responsibility for your legal literacy because no one else is going to do it for you. Think of it like driving a car in heavy traffic. You can know all the traffic laws, you can know your rights of way, and you can know exactly where you are allowed to go. But if you assume that everyone else on the road is going to follow those same rules, you are going to end up in an accident. You drive defensively to protect yourself from the mistakes of others. You need to treat your legal rights the same way. Know the law, but act with the understanding that the person enforcing the law might not be operating with the same information that you have. This is the bigger picture that so many people miss, and it is why this ruling is not just about a single case in Rhode Island. It is about the fundamental power dynamic between the citizen and the state. For decades, the courts gave police a wide berth, allowing them to use broad, vague justifications to bypass the Bill of Rights. That era is beginning to change, and that shift is creating friction. Every time a citizen pushes back and asserts their rights, and every time a lower court is forced to apply this ruling, the boundaries of police power are being tested and reshaped. If you are a first-time gun owner or someone who has carried for years, this is a moment to take your knowledge seriously. You need to understand that your firearm is a right, but it is also a responsibility that requires you to be informed about the legal landscape. When you carry, you are not just carrying a tool for defense. You are carrying a constitutional right that is under constant pressure from various legal interpretations and police practices. Staying informed is not just about staying out of trouble. It is about respecting the weight of that responsibility. Consider the consequences of not being prepared. If your firearm is seized during a caretaking incident, you might be looking at months of legal fees, potential charges if the officer decides to twist the story, and the stress of dealing with an adversarial system. The legal system is slow, expensive, and often biased against the gun owner. Preventing that initial seizure by clearly asserting your rights while maintaining a respectful and non-threatening demeanor is 100 times easier than trying to fight to get your property back once it has been taken. Looking ahead, we are going to see more of these cases moving through the court system as plaintiffs challenge the misuse of community caretaking and other vague police powers. We are likely to see conflicting rulings in different states, which means the Supreme Court might have to step in again to clarify the boundaries. This is the nature of constitutional law. It is a slow, grinding process of constant adjustment. As an engaged and informed citizen, you need to understand that this is not a one-time event. It is an ongoing process of defining what your rights actually look like in the real world. Ultimately, your safety is your own responsibility, and that includes your legal safety. No politician, no media outlet, and no lawyer can protect you as well as you can protect yourself by knowing the rules and behaving accordingly. You need to be the person who stays calm, who knows the law, and who understands that your silence and your refusal to consent to a search are not signs of guilt. They are the hallmarks of a free person who understands the gravity of their constitutional protections. This is not about confrontation, it is about dignity and the rule of law. When you walk away from a stop, you want to be able to say that you handled it with the utmost respect for the officer and for your own rights. That is the goal. You want to avoid the traps, you want to avoid the confusion, and you want to ensure that you are never in a position where you are being forced to defend your rights in court because you didn't know how to assert them on the street. It is a high bar, but it is one that you can meet if you commit yourself to understanding the nuances of the law and the reality of the environment you are operating in. To wrap this up, remember 3 things. First, the Supreme Court has clearly signaled that the community caretaking doctrine is limited and cannot be used as a blanket excuse for warrantless searches and seizures. Second, police departments and individual officers are still operating with a lag time, so you must be your own advocate in every interaction, assuming that the person you are talking to might not be following the latest legal standards. Third, your demeanor is just as important as your legal knowledge. Stay calm, stay respectful, and stay firm in your refusal to consent. These are your tools for navigating the modern legal landscape. This issue matters because it hits at the core of what it means to live in a free society. It is about whether the state has the power to interfere with your property and your peace whenever they claim to have a good intention, or whether your rights are protected by a line that the government cannot cross. You have a stake in this, your family has a stake in this, and the future of our constitutional framework depends on people being aware of these rights and willing to stand up for them in the proper, legal, and respectful way. The future of these rights will be decided in courtrooms, but it will be shaped by the reality of what happens on our roads and in our communities. You are part of that reality. by being informed, by understanding the law, and by being the kind of person who respects the process but refuses to surrender their rights, you are doing your part to ensure that these constitutional protections remain strong for the next generation. Do not take this for granted. The law is a living thing, and it requires constant attention and defense from people just like you. If you are someone who believes that our constitutional rights are worth understanding and defending, join our community. We are building a group of people who are committed to real legal education without the spin, and we would love to have you with us as we continue to break down the issues that actually matter. Subscribe to stay updated and leave a comment below to let us know what you think about this shift in police power. We are all in this together, and the more we share, the more we learn, and the stronger we become.